A very good evening, ladies and gentlemen. We welcome all our members and guests to this very important and interesting webinar. To start with this webinar, I request my Vice Chairman, Mr. Avinash, Director of Phoenix Group, to kindly give welcome remarks. Please, sir.
Hi, everyone. Good evening. I am Avinash from IACC. On behalf of IACC, Andhra and Telangana branch, it gives me immense pleasure to welcome you all for today's webinar. As you're aware, IACC AP and Telangana is organizing a webinar series on navigating cross-border business disputes from courts to arbitration and insolvency solutions. Today, we are starting this series with first webinar on exploring dispute resolution mechanisms, a deep dive into global court systems and international commercial arbitration. In today's session, discussion will focus majorly on various dispute resolution mechanisms, focusing specifically on the role of courts and international commercial arbitration in resolving cross-border business conflicts. Participants will also gain a clear understanding of the processes, benefits, and limitations of each approach, empowering them to navigate the complexities of international dispute resolution effectively. We extend a special welcome to our speakers, Mr. Avinash sir, as well as Mr. Naveen sir. Mahajan. Thanks to all members and guests for joining us today. Now, I would like to briefly introduce our speaker, Mr. Avinash ji. Avinash ji heads the firm's Hyderabad office and the firm's South India dispute practice. He specializes in advising clients on complex competition law and dispute matters. He is an advocate on record with the Supreme Court of India. He regularly appears and argues before the Supreme Court of India and various high courts like CCI, NCLAT, NLCT, and other tribunals in India. Avinash ji has extensive experience of handling complex cartel vertical restraints and abuse of dominance investigations. Avinash ji also has represented clients in several merger control matters requiring complex remedies. He also regularly advises and represents leading global and Indian corporates on their disputes across South India. He has specific experience in handling constitutional and administrative challenges, matters under the Insolvency and Bankruptcy Code, and commercial disputes. I would also like to brief you all about IACC. IACC is an apex bilateral chamber synergizing India-US economic engagement. We serve to both the Telugu states, Andhra and Telangana. IACC regularly organizes seminars or webinars and interactive meetings for our members. IACC works closely with the state governments for policy formulation, advocacy, and representing on policy issues on behalf of Indian and American companies for trade-related matters. We work closely with the US Consulate on issues related to visas, trade barriers, and other pertinent matters. We facilitate B2B meetings for inbound delegations from the US with industry sectors in India, arrange outbound delegations to US in coordination with our partners in the US, and identify potential partners, etc. IACC coordinates meetings with trade development missions for promotion of bilateral trade. We work for different industry sectors and for different business segments through subcommittees. We have overall 12 branches all across India, and also they have the same rights and privileges in other cities as well to avail the benefits. With these words, I wish a very productive and fruitful session. Thank you all.
Thank you, sir. Thank you for the welcome remarks. Now, I request Avinash ji to take over. And just to mention for the members and all the participants, we'll be sharing the PPT of the session with you for your reference. And also, if you have any questions, please post them in the question answer box or chat box. And after that, we will take and we'll request Avinash ji to answer all the questions. Thank you. I request you, sir, to take over. Thank you.
Thank you. Thank you so much, Avinash, sir. Thank you, Shika. So before we start, I think somebody had their hand raised. I don't know if it's a technical issue. Roshan, is it if you're not able to hear us or something, but I just want, before we start, somebody had their hand raised.
Presently, the voice is clear.
Yeah, okay.
I am closing my video and audio so that it is more better than
Sure.
Yes.
So
And you can share, sir, your PPT here.
I'll just do that. So I hope my screen is visible to everyone and I'm audible. So very good evening, everyone. Thank you so much, Avinash sir, Shikha, for this opportunity. I think the purpose of this webinar series is that we wanted to introduce to the members, and hopefully the members will find this useful. But we are all, the Indo-American Chamber of Commerce has a lot of businesses who have commercial relations and who have transactions on a day-to-day basis with parties abroad. So there are parties in India, there are parties abroad, and even domestically in your day-to-day commercial transactions. Dispute resolution becomes a very, very important topic, but something that at least I have seen in my experience with clients at the time of negotiating contracts generally gets relegated towards the end and almost becomes like a boilerplate clause. Nobody pays a lot of attention to it. Of course, we all hope that there is no dispute that arises, but if a dispute does arise, having the right dispute resolution clause in your contracts can be very, very important in the long run. So the idea, at least today, is to just introduce a very, very broad overview of what are the different types of dispute resolution mechanisms one can explore, and also try and give you a very a brief analysis of the relative advantages of each system. I would obviously, there is no single answer and no straitjacket formula that this is the best form of dispute resolution. It would depend on the facts of each transaction, what is the best. But at least the idea is to give you an introduction that these are the relevant, the relative advantages and disadvantages of each form of resolution. We hope to follow up in our subsequent webinars on more specific sectors and more specific forms of dispute resolution. So you can treat this almost as the introductory session, and in the subsequent webinars we'll be going taking a deeper dive into the specific forms of dispute resolution. So just very briefly, the slide will be circulated to you, but just to introduce ourselves, we are Chandhiok and Mahajan. We are a full service law firm. We have offices across India, Delhi, Mumbai, Bangalore, and Hyderabad. We regularly advise not just Indian clients, but large multinational corporations. And we do have specific experience in navigating cross-border disputes. So very quickly, let me just jump in straight away. We have an hour and a half. So I think my idea is to spend an hour all the way up till around 5:30 to sort of go through the slide deck, and then the last half an hour we can leave for question and answers and discussion. So coming to choosing the right dispute resolution mechanism. So you would see that a dispute clause is almost common in every agreement you negotiate, even sometimes in purchase orders, in invoices. Parties usually have a standard boilerplate dispute resolution clause. And very often when we are negotiating a contract or we are negotiating commercial terms, this is this is usually the last or the least discussed clause, I would say. Generally people just accept whatever is suggested in the standard form of the contract. However, and this is, I think, what the idea was to introduce through this presentation, the choice of your dispute resolution clause can have a profound implication for you if a dispute were to arise. And some of the factors that you must keep in mind, and these are what we hope to discuss more in the further slides, are, one is the choice of law. So, there are, I would say, and, of course, there are differences, but broadly in the globe, we have two systems of law. We have what we call the continental system of law, and we have common law jurisdictions. So common law jurisdictions are mostly those countries which were formerly British colonies and still follow, have, at least they have their base in the what we call the common law, the British system. Continental law systems are more found in Central Europe, Germany, France, etc. Very basically, the difference would be that common law jurisdictions tend to leave a lot more interpretation to the courts. The laws are a lot less detailed and procedural. They are mostly, they deal with the substance, and they leave a lot of interpretation room for the courts. This obviously has its advantages because it gives flexibility, but also at the same time, the disadvantage is sometimes that there is a lot of uncertainty. On the converse, a continental system of law generally has a lot of codified rules. So, they try to codify into and put down into law as much as possible all the rules, and therefore, courts have a lot less flexibility. But each has its own advantages and disadvantages, and sometimes depending on your preference, and let's say you are negotiating, an Indian party is negotiating with a German party, whether the contract is governed by German law or Indian law may change how the contract is interpreted entirely. So that is something to consider. Then there's the issue of jurisdiction. So again, each law has its own rules as to which court would have jurisdiction. Another issue is also neutrality, and neutrality to avoid bias. So generally you would, if both parties are from the same country, it's then at least it goes without saying that, the law of that country, or we would choose that country's legal system to govern. But if it's a cross-border transaction with parties being from different countries, a preference may be to have a neutral third party so that there is no allegation of bias later on. If for example, as the same example between an Indian and a German party, if we choose German courts or German laws, there might be some doubt in the mind of the Indian party that, will the German courts be biased towards their own, the party from their jurisdiction. Flexibility is another factor, as I was pointing out. Some legal systems and some court systems offer more flexibility than others. The time and the costs also, and goes without saying, in India we know that courts take forever and ever to resolve disputes. So if you want a timely and cost-efficient method of dispute resolution, you may look outside the court system into what we call ADR, or alternative dispute resolution mechanisms. Equally, privacy and confidentiality becomes a very important aspect, because if you choose courts to resolve your disputes, usually everything comes out in the public domain. All of the court pleadings, everything are published. So if it's a dispute relating to some sensitive information that you don't want to be disclosed, again, that is for that, you may have to choose an ADR, or an alternative dispute resolution mechanism. And the last, and I would say the most important consideration also becomes the enforceability and execution of an order. So one thing is to get an order in your favor, and then the second challenge is to actually execute and make sure that somebody complies with that order. So again, this again especially becomes a big consideration in ADR mechanisms, because in alternative dispute resolution mechanisms, you have an arbitrator or somebody outside the formal court system making a decision for you. While most laws recognize these decisions as orders of the court and are enforceable, in practice, challenges do arise, especially when it is, let's say, an arbitration award or a decision from another country. So sometimes there are another set of checks to see whether that arbitration award was passed in accordance with certain basic rules of fairness and procedure. So these are all different considerations which become very, very important when you're choosing your dispute resolution clause. Now, very, very broadly, what are the three types of international dispute resolution mechanisms we have? I will make a note here. There is a fourth type, which is not really a dispute resolution mechanism, but another tool that you may have, which is insolvency. But that's something we hope to cover in the subsequent webinar. But in insolvency, recourse is not really a dispute resolution mechanism. It's more considered, when a company is unable to pay its debts, then the procedure is also completely different. So we'll deal with that separately. But very broadly, you would have, and to put it very simply, you would have three types of dispute resolution mechanisms. You have litigation, which is your regular court system. So if there's a dispute, one of you goes to the court, you file a case, and the court will then hear and decide, decide the matter. Then there's arbitration, and I say international arbitration here because we're looking at this from the lens of cross-border transactions. But what I talk about arbitration equally applies to domestic arbitrations or disputes between parties from the same country. So arbitration, we'll come to it, is outside the court system, and then there's mediation. Now, the first one, which is usually the more obvious one and the traditional one, I would say, is litigation via the court system. This is while in India, I think the thinking over the last 25, 30 years has been that courts could lead to significant delays, and therefore people try and avoid going to the courts. It can still be, and especially in light of certain recent efforts by the parliament in India, especially to speed up the court system, it can be an effective dispute resolution mechanism as well. So it's something that you should keep in mind. And especially talking about a cross-border context, some of the court systems in the other countries are quite effective, really fast, and do work almost as fast as alternative dispute resolution mechanisms. In my experience, I've seen, especially when it comes to court systems, people do prefer the English courts a lot because the UK courts are seen to be quite efficient and very, they're quite time sensitive, and the decisions do come out well and quite robust in their procedures as well. So the first consideration when you're looking at choosing a court system is the choice of applicable law. So to break this down, there are two things, right? There's what we call the substantive law, or the law that would govern the contract. And then second is the law or the courts that would govern in case of a dispute. Now, these usually are the same, but need not be the same. So let me give you an example. So for example, you may say that, the laws of India will be governing, a particular contract. But if you decide that you want to go to arbitration, the arbitrator can sit in Singapore or can sit in London or wherever, but he will apply Indian law to the contract when he's deciding a dispute. However, what you cannot do is confer jurisdiction on a court that does not have the power to enforce that law. So what you cannot do is to say that the contract would be governed by Indian law, but the courts in England will have the jurisdiction to decide disputes, because the courts in England are not competent or do not have the power to apply Indian law to the contract. So therefore, generally, you would try, and at least in the court systems, you would try to harmonize the law that you apply to the contract and the courts that you choose. Otherwise, you will face an issue that courts may decline jurisdiction if another court or forum is more appropriate. Second, and this again comes down to what you have to be careful about when choosing a court system, is jurisdiction. So the basic rule is that you cannot confer by contract jurisdiction on a court that does not have it in the first place. So there are certain rules set down in the law about which courts have jurisdiction. And these apply both territorially in terms of subject matter and in terms of the monetary level. So to give you a very simple example, within India, a couple of high courts in a few states have what we call original jurisdiction, meaning that they can take up even commercial disputes in the first instance. For example, the Delhi High Court. So the Delhi High Court can entertain commercial or any sort of suits above the value of 2 crore rupees. So if you were to, let's say, agree that Indian laws would govern, and you say that the Delhi High Court would have jurisdiction to entertain the dispute, but your claim amount is below 2 crores, then even though by contract you have agreed that the Delhi High Court should govern the dispute, it cannot, and it will decline to entertain jurisdiction. So you need to check, and you need to have your lawyers check in your dispute resolution clause whether the courts that you are deciding for in your contract actually have proper jurisdiction in the facts of your contract. Another consideration to keep in mind when you're looking at the court system is the appeal system. And the appeal system works both ways. If you are successful, you obviously want to spend lesser time on an appeal. But on the other hand, equally, if you are unsuccessful in the first instance, you do want a second bite at the cherry, or you do want a second opportunity. So it's good to assess in terms of how many layers or levels of appeal are available in a court system, how much time do appeals usually take, And again, to take the classic case of India, sometimes, when we look at the delays in the Indian system, we usually take the entire process, right from the district court to the Supreme Court. Sometimes cases could take as much as 25 to 30 years. And therefore, and a lot of that time is actually spent in appeals and not really the first decision. And lastly, another consideration is to look at the scope of the appeal. And what I mean by scope of the appeal is that in some court systems, and for example, in India, you have, let's say you get a decision from the lowest court or the district court. You have a first appeal where you can appeal on everything, facts, legal points. You can basically, it's like a rehearing of the case. However, from the second appeal onwards, the points of appeal are only restricted to legal questions. So the facts get crystallized at the first appealance or at the first appeal stage. Now, the purpose of doing that, at least in the Indian system, is to reduce the time and to make sure that cases are disposed of quicker. Because if at every level of appeal, if a court is sitting and rehearing the entire matter, looking at all the facts, cases would never get decided. However, you might have, again, as I said, you might have some other systems where the rules are slightly different, where you get a full-blown appeal at 2 or 3 instances. And perhaps that is beneficial to you in the context of that contract. So that is, again, another factor to keep in mind. And the last important point to keep in mind is enforceability. So there are, and when enforceability especially becomes important in the context of international contracts or cross-border transactions, because of political reasons or because of other reasons, sometimes there are certain countries whose courts or whose decisions other countries may refuse to recognize. And therefore, that's again something to consider and check with your lawyers when you're negotiating the contract as to whether decisions of law courts in that country, are they recognized in the other country or not? Because otherwise you may face a hurdle. Even if you get a favorable order in a different country, if you have to enforce that in a different country, you may face hurdles. So that's also another factor to keep in mind while looking at the court system. Now, in India, for commercial disputes, as I was saying, the Indian Parliament in 2015 enacted a specific legislation called the Commercial Courts Act. The entire purpose of enacting this legislation was to establish separate courts called commercial courts and lay down certain fast-track procedures for them to ensure that commercial disputes get disposed of in a speedy manner. I'll give you only the highlights. Of course, there's a full-blown procedure that is prescribed. First, the Commercial Courts Act, they laid down a certain threshold. So 0.3 million, that's 3 lakh rupees. So any dispute which exceeds this amount and arises out of ordinary commercial transactions. Now, the definition of commercial transaction is quite wide. It's not just regular supply of goods and services, even intellectual property disputes or anything which has a commercial angle can qualify as a commercial transaction. However, with this threshold, and that's why I say, it's very, very important to actually take the dispute resolution clause seriously. While the central legislation has prescribed a threshold of 3 lakhs, some states have actually increased that threshold. So, for example, our own state in Telangana, by a notification, the state government has said that this threshold has been increased to 1 crore rupees. So, therefore, in Telangana, if your dispute is below 1 crore rupees, you cannot go to the commercial court, you have to go to the regular courts. So I would say even this threshold, please do check, because there are certain state-specific amendments which may have prescribed different thresholds. Now, how does the Commercial Courts Act change the procedure for commercial dispute? So the entire premise of a commercial dispute is that there are, let's say, undisputed dues payable. The other party has acknowledged liability several times, but they're just not willing to pay for whatever reason. Let's say it's a claim, you have a money claim and the other side wants to pay, but they've not been paying for whatever reason. And you want to make sure that you pursue some quick resolution of the dispute, get an order in your favor and try and execute it. So in such cases, the commercial courts say that we can dispense with the regular court procedure of having to go through the evidence, doing cross-examination, filing evidence, etc. So if you are able to clearly show that, prima facie, at least from documents, that there's a clear admission of liability, then the court shifts the burden onto the other side to say, now you show me, do you have some reasonable defense? If you don't have a reasonable defense, then I will skip the entire process of trial. I will skip the process of having to lead evidence, file documents, do examination, cross-examination. I will straight away take it to final arguments and I will pass a decree. So we call this leave to defend. So basically, once a suit is filed in a commercial court, the other side has to come and file an application seeking leave to defend. So in that, they have to show that they have some reasonable defense. If the court is not convinced that they have a reasonable defense, then we skip the entire trial process and go straight into final arguments. The other very important thing that the Commercial Courts Act introduces, and that's where, and we'll talk about this, this is the third method of dispute resolution that we were looking at, is that the Act says that before filing a suit, parties must mandatorily attempt mediation. So the idea here is to make sure that they have tried all methods of amicable dispute resolution. And very often in my experience, parties do want to avoid going to court, and therefore this mediation does help, and disputes often get resolved at this stage itself. In those cases where the mediation fails, then obviously we go into this fast track suit procedure. The only exemption to pre-litigation mediation, although recently there have been several decisions of the court saying that this exemption should be granted in very exceptional cases. But in some cases, if there's some urgent interim relief that you're seeking, for example, you feel that the other side may try to sell off its assets or try to escape and liability, and you need to get an urgent interim order from the court to protect you, then you can ask for exemption from the pre-litigation mediation. So these commercial courts, again, as I said, they have been constituted both at the district level and in those states where the high courts have original jurisdiction. As I said, they can hear a case afresh. Some high courts also have the commercial court powers. So this is a brief about the court system. Now coming to the next system, which is arbitration. So again, this is a word you would have heard very, very often. So what is essentially arbitration? Arbitration is very simply put, is an agreement between two parties to refer their disputes to a neutral third party, and both parties agree to be bound by the decision of that third party. So you are, rather than going to the formal courts set up by the government, you are appointing an arbitrator based on your own contractual agreement, and both of you are agreeing to be bound by the decision of that arbitrator. And an international commercial arbitration is an arbitration where the two parties are not from the same country or the same jurisdiction. Now, the most important and the most basic aspect, and so I know people are raising hands. Should I stop, take questions now, Shika ma'am, or should we? Yeah,
no, sir, I have requested all the members to put their question in the chat box, and later we can take it.
Okay, sure.
I request members kindly put your questions in the chat box instead of raising your hands, please. Thank you.
No problem. So the most essential principle about arbitration, and this is where actually a lot of, sometimes a lot of litigation gets generated from arbitration, is that arbitration is a creature of agreement between the parties. So it is only when both parties consent to be bound by an arbitration does arbitration start and arbitration can function properly. Another very important principle about arbitration is that courts have consistently recognized that even though an arbitration clause may be in your main agreement, it is a standalone agreement in itself. So irrespective of your main agreement, the arbitration agreement can stand separately. So therefore, sometimes, to give you a very basic example, sometimes parties raise arguments like, I terminated the contract which had the arbitration clause, so therefore you cannot invoke arbitration. So to avoid situations like that, courts have interpreted arbitration agreements to say that even though they are contained in another contract, they may be contained anywhere. They may be contained in an agreement, in a contract, in a purchase order, in an invoice. But as an agreement, it has an independent existence. And therefore, even if the main contract is terminated, the arbitration agreement survives, because that is to ensure that these disputes are resolved out of court and in a timely fashion. However, international law has recognized that, and although you would know that we can conclude contracts orally and through other understandings, to make sure that there is some level of certainty, the arbitration agreements have to be in writing, and usually only then they are recognized by most laws across the world. The other thing that most laws across the world have done, and we also have our own Arbitration Act, is that to give legitimacy to the decision of the arbitrator, most laws will declare that an award or a decision passed by an arbitrator is enforceable just like a court order. So let us say there is an award in your favor by an arbitrator, the other side is still not respecting it or following it. You can then go to the court and say that we had this arbitration, this award was passed, the other person is not abiding by it, please take action against him. And the courts have powers under the laws to attach their property or to basically realize the amount in several ways, and that can even include imprisonment if they don't ultimately follow the award. So a few salient features of arbitration. One is it's a voluntary process, as I said, so consent is paramount. Two, very big difference from court systems is that it is entirely private and confidential. So arbitration proceedings are not uploaded on any website anywhere. The entire proceedings remain between the knowledge of just the parties and the arbitrator. And third is, of course, the idea is that the arbitrator should be neutral and independent. There are ways in the laws to ensure their independence. If there's a conflict of interest, the other side can point that out, and a court can then appoint another arbitrator. Now, within arbitration, there are two ways of conducting an arbitration. So one is what we call an ad hoc arbitration. So an ad hoc arbitration is where parties appoint an independent arbitrator on their own, or even an arbitral tribunal is where there are more than one arbitrators, and they just choose a person on their own. Today, for example, two parties could choose Avinash to be the arbitrator, and that's an ad hoc arbitration. So generally there will be a clause. The clause in the contract itself will provide as to how they have to choose an arbitrator. Usually it has to be by mutual consent. But there are different ways. So sometimes one party will say, I will provide a panel of 3, and out of which you can choose one. Or sometimes if you have an arbitral tribunal of 3 arbitrators, each party will appoint one, and then the 2 arbitrators will appoint a third arbitrator. So these are generally the common ways of appointing an ad hoc arbitrator. In ad hoc arbitration, the arbitrator will charge their fees as per the law governing the arbitration agreement. If the arbitration agreement does not talk about what fees it should be, then it follows whatever the law prescribes. They hear the case and they pass the award, which then get enforced by local courts. The other thing you can do is, rather than you having the headache of having to prescribe the procedure, talking about what are the fees, etc., and this is it's preferred by a lot of parties because it makes it a lot more simpler for the parties. You can just choose to refer the arbitration to certain institutions. Now, these are voluntary institutions formed in different countries. Their entire purpose is to conduct arbitration. So they provide facilities. What facilities do they provide? They provide rooms. Most importantly, they provide arbitrators. They have a panel of arbitrators. So you just have to say that the arbitration will be conducted by XYZ institution. And then when the arbitration actually happens, that institution has a full set of procedure as to how the arbitration has to be conducted. And they will have their own fee structure, etc. And their own procedural rules. So prominent centers that are usually used in India, at least, there are 2 very prominent centers, the Mumbai Center of International Arbitration and the Delhi International Arbitration Center. In Hyderabad, of course, we also have the IAMC, which is the International Arbitration and Mediation Center. Internationally, the Singapore International Arbitration Center and the International Chamber of Commerce are very, very famous. The London Chamber of International Arbitration is also quite famous. So in such cases, your contract would simply say that the 2 parties would resolve their disputes by way of arbitration. Arbitration would be conducted in accordance with the rules of the SIAC, for example. That's all you have to say in your contract. After that, SIAC's rules, the procedure, everything will be governed by SIAC. So that is the other way of conducting an arbitration. Now, within India, of course, it's much, as I said, enforceability, it's fairly simple because the award is treated as an order of the court and you can enforce the award. when it is a foreign arbitral award. So for example, in the previous slide, as I was mentioning, let's say that, the award is passed by the Singapore International Center, and the arbitrator is a Singaporean person. He has passed the award in Singapore, but you have to enforce it against a party in India. So then the law does provide that a foreign arbitral award is recognized, but what would happen is there would be an extra level of checks. So the court may not directly simply, enforce the award. So for example, let's say that, the award passed in Singapore, the other side comes to India and challenges the award in court, saying that, no, this is something completely, to give you an example, this is completely contrary to the basics of Indian law. Let's say it says that, the contract need not have consideration at all, or something very, very basic. So in that case, the courts will first look at the award and see whether it complies at least to the basics. The basic procedural requirements and international standards are complied with, and that it is not it's not contradicting basics of Indian law. Only then they will enforce the award. So that may take a little bit of more time. And in terms, for example, for us, in terms of thinking about enforceability, if it's a foreign award, enforcing it in India, while it is possible and definitely it happens regularly, it may involve a slightly more detailed procedure, because the court is doing a basic check whether this award complies with the basics of Indian law. However, there have been recent efforts made to harmonize as much as possible arbitration procedures and awards across the globe, so that this little time, this extra time is saved. So there is a lot of effort to harmonize practices and procedures across different countries, and also to adopt technology to try and make the procedures uniform. So hopefully going forward, enforcing foreign arbitral awards should not be as difficult as it is today. Not that I would not say it is very difficult today, but it can take some time, at least, and definitely more time than a domestic arbitration award. Now, just to give you a quick, sort of very, very brief overview of how Indian courts have approached arbitrations. So generally across the world, and you would have heard this at perhaps a lot of other seminars, that the entire purpose of arbitration is to avoid the technicalities of court. And the idea is always to have as minimum court intervention as possible. And that is when arbitration can work effectively. Because if there are constant delays, courts constantly intervening or staying arbitrations, or interfering in orders passed by arbitrators, then it would become just like a court case, right? It would take as much time. Indian courts, and to my experience, seem to be caught in a dilemma, and which is why I've just put that on the left and the right here. And that's, on the one hand, there are a lot of judgments that will wax eloquent about how party autonomy must be respected, arbitration procedures must be respected because it's ultimately freedom of contract. There should be minimal intervention by courts, and there must be as much power given to arbitral tribunals as possible. But equally, you will see a large set of cases where Indian courts do actually interfere quite a bit. And usually the justification is to ensure justice, to enforce the law, that certain decisions are against the basics of, procedural fairness or basics of Indian law. So it's very difficult to summarize the approach of Indian courts because, as I said, they are constantly in a dilemma between these two. So you will find judgments on both sides. You will find judgments, as I said, on one side saying, courts should completely, basically accept everything that the arbitrator says and not interfere at all. Equally, you will find cases which would say that, no, but courts do have a duty to interfere when there is a need to ensure complete justice. So overall, it's been a mixed, I would say it's been a mixed approach for Indian courts to arbitrations. But generally, at least on paper, the principle is always that court interventions should be minimal, and that's when arbitrations can work effectively. Now we come to the next method of dispute resolution, which is mediation. Now, I think just before starting, I think one point I'd like to make about mediation is that I would often see mediation not as an alternative to the other two that we saw, to litigation and to arbitration, but more as complementary. And you'll see why. Like in fact, we looked at the Commercial Courts Act just a few minutes ago, and you would see there that mediation is considered a mandatory step before filing a case. So very often mediation is seen as complementary to these two methods of dispute resolution. Even in arbitrations, very often you will see contracts which say that first parties will attempt to amicably settle disputes or will attempt mediation. If mediation fails, then they will get into arbitration. So in that sense, I would say mediation is a complementary method, and so far that's how courts and legal systems used to look at it. But at least in India, over the last 2 years, there's been an increasing push towards mediation as becoming a standalone and a really independent and focused method of dispute resolution. And that's because there are certain very obvious advantages that mediation provides. So first and foremost, what is mediation? So the big difference between mediation and arbitration is that in mediation, again, you refer your disputes to a third party. That's not a court. However, that third party's mandate in a mediation is only to facilitate or enable you to arrive at a settlement. So he does not have power to bind you. He does not give a decision. He only facilitates. He only tries to talk to the parties, tries to make them arrive at a consensus. So in that sense, the certainty is much lower, of course, because it's entirely up to the parties. But equally, there is a lot more flexibility to parties because ultimately it is based on whether parties are able to arrive at a consensus or not. And because it is entirely up to the parties, it can sometimes be very cost and time effective, because if parties don't want to spend too much time, they will try to wrap it up as quickly as possible, and it can be decided very, very quickly. That would also save you cost. As I said, the only point that we should keep in mind is that it's non-binding. Otherwise, of course, a mediator is also again supposed to be neutral. Just like arbitration, it is again a confidential process. And as I said, it's completely based on voluntary participation by parties. Parties can usually opt out of mediation at any point of time. And it offers a lot of flexibility. So, few recent developments, as I was saying, increasingly that mediation gets, sort of complemented with arbitration and litigation. And equally, especially after COVID, I think there is a major push towards online and virtual mediation platforms, which help for parties parties who are even remotely placed can try and arrive at a consensus through online mediation. So again, the Indian government and the Indian Parliament passed a legislation called the Mediation Act in 2023, with the goal of really putting mediation and sort of having a separate procedure for mediation as a dispute resolution mechanism. There are different types of mediation that the legislation envisages. It talks about pre-litigation mediation in the context of Commercial Courts Act, of course. But equally, it now provides that you can have voluntary pre-litigation mediation. So any dispute, let's say even if it's not a commercial dispute, there are certain specific institutions envisaged under the law. There's something called a Mediation Council of India, which would regulate mediators. And just like how you have arbitral institutions like MCIA and SIAC, at least the law envisages that there would be mediation service centers or mediation service providers. So you could refer your dispute to them. You can try and get it mediated through them. It also talks about, it also talks about international mediation and community mediation. So community mediation is when there are issues affecting an entire locality or a community, when that can get mediated. There is a strict time frame now envisaged for mediation, which is a total of 180 days. And just like an arbitration award, which is a very, very welcome move, any agreement that you arrive at after the mediation can be enforced like a court-issued judgment or decree again. So that gives it a certain level of certainty. And another very important aspect is that very strict confidentiality is provided in the Act, because very often what happens is parties are a little, and maybe you would have seen this in your experience, or at least I've seen this in my experience doing mediations is that parties are a little wary of, sort of opening their cards or making offers freely, because what they feel is that if the mediation fails, whatever they say in the mediation can be used against them in court. So the Mediation Act has a very strict bar against that. It treats whatever happens in the context of a mediation as legally privileged and confidential, and therefore parties or even the legal advisors, anybody cannot use any information or document that has been discussed or provided in the context of a mediation. So the idea is really to facilitate an open discussion and a free discussion, which would ensure that ensure maximum success and make sure that the mediation system works. So I think, yeah, this is, I think, where we wanted to give you. We've looked at the basics of the three methods: litigation, arbitration, and mediation. And this is just to give you a very, very quick sort of heat map of what are the relative advantages and disadvantages of each. Again, I think just to reiterate what I was saying, I don't think the conclusion or the suggestion here from us is that one method is the best in all cases. As I said, it depends on the facts of each of your transactions or the contracts that you're negotiating, what would be the best. And of course, you have to think about it from your business considerations as well, what would be the best mechanism. But I think the idea is to give it more thought, because very often, as businesses, people tend to just ignore the dispute clause as a standard boilerplate clause that's on the last page, and nobody even gets there. We're more concerned about just the main commercial terms, what are the payment terms, what are the supply terms. But do give it a glance and have your legal team or anybody with a legal mind to just check it to make sure that it is in your interest. So different factors. So first, voluntary participation. So in litigation, once you go into a court, it's not voluntary. If you get a notice from the court, you have to appear, right? And that can be a big disadvantage, because in court, once you get into court, then there's no way to get out of it. Whereas in arbitration and mediation, it's voluntary. It's completely based on consensus of the parties. Flexibility, as I said, mediation has very high flexibility. In fact, one of the other things very important is that in mediation, the law itself, the new Mediation Act itself provides that the mediation agreement can even go beyond the scope of this dispute. So very often what you can do is probably do a trade-off. Let's say you have some other transactions with that party, and you do a trade-off. You say, okay, I'm going to waive off this payment, but subject to you paying that. So that sort of mediation agreement can also be reached at. With arbitration, I would say the flexibility is medium, and the reason I say that is that arbitration is ultimately, he has to stick to that particular agreement or the dispute that is referred to him. They can't go beyond the scope of what is the dispute. In litigation, of course, in courts, the flexibility is the least, because you are governed by very strict procedures. Of course, as I said, some of those procedures, the Commercial Courts Act tries to make less burdensome, but overall, it's still a little bit more cumbersome than the other procedures. Confidentiality, again, as I said, in court systems, it's not possible for you to keep things confidential, because courts are public. They will publish everything. Therefore, if there are disputes which involve trade secrets or commercially sensitive information, you're better off going into arbitration or mediation, where the proceedings are kept completely confidential. The most key factor, I think, and this is something that businesses always worry about, which is time efficiency, is I would say a mixed bag. Except with the exception of mediation, of course, mediation can actually be quite time efficient. But again, I would caveat that with a warning that mediation works and is time efficient only if both parties to the mediation approach it with that serious intent of settling a matter. Because what I've often seen happen is also that one party which is simply trying to drag out things and is not serious about mediation you can never reach a consensus in mediation with such a party. And secondly, such a party will just use mediation as a excuse to further drag the dispute out. So the intent of the parties also is very, very important. But subject to that caveat, mediation, if both parties are serious about it, can be very time efficient. Arbitration can be moderate, because again, arbitration, there's a lot of flexibility in terms of the procedure. They don't have to strictly follow the rules of evidence and procedure that courts have to follow. So they can fast track, and there are strict time limits under the laws of most countries under the arbitration laws that they have to deliver their verdict within a certain time frame. With court system, the reason I put depends is it would depend on which court system you choose. As I said, India, I think the answer is obvious, I think sometimes. But again, I would say even with India, I would caveat it, but that some high courts have really picked up their pace. And very often I have seen, at least in recent years, that courts render decisions faster than arbitrators as well. To give you two examples from my experience, at least, the commercial courts in Bangalore, I have seen are very, very commercially minded and fast. And very often the time taken is almost the same as an arbitration or even lesser. And the Delhi High Court, in exercise of its original jurisdiction, also is very fast. And internationally, as I gave you examples, the courts in UK generally are quite trusted because they are speedy and robust. So in litigation, the time efficiency would depend on the court system that you choose. Then in terms of ensuring that the decision is binding, obviously courts have the most amount of binding nature because they can enforce it. Arbitration also can be binding because it is enforceable as an award of a court. With mediation, there is no binding nature. And the reason I say this is because the ultimate outcome is based on an agreement between the parties. So a party can opt out of mediation at any point of time, and then the mediation can fail. Once an agreement is reached, then that agreement can be enforced as an order of the court, but the parties can opt out at any point of time. Then in terms of structure, again, this is in terms of rules of procedure. Court systems can be quite rigid. Arbitration is much more flexible in terms of the structure, the way it's conducted. Very often arbitration, is conducted in either centers or with, the arbitrators' homes. It can even be online. Mediation is, of course, again, very facilitative. In terms of costs, the litigation costs can be quite high, and this is mostly because of, there's a court fee that's payable. Cases drag on for years and years, so you spend a lot on legal fees. With arbitration, it's moderate, I would say, because at least, there's a time-bound nature of an arbitration, and the fees are also governed by certain specific rules that you pay the arbitrator. With mediation, the costs are the least because there's a mediator fee that you have to pay, obviously, but because of the time that it takes, if you're able to solve a dispute very quickly, you can also save on costs. Then in terms of enforceability, of course, litigation gives you a high level of enforceability because it's a court order. And arbitration and mediation I would say put in depends, because in arbitration, as I said, the issue is with the foreign awards. Sometimes enforcing a foreign award in another country can be tricky. And with mediation, as I said, if you don't reach an agreement, it becomes difficult. But if you do reach an agreement, at least now efforts are to try and enforce it, almost like a court order. So I'll stop here for now, and thank you very much. And I think we can start with the questions because I can see quite a few hands